Lawyer. Today I'm going to discuss about the changes that have been brought into for the EU settlement scheme. Very important changes. The main one being administrative review, which was clogged into the system, that has been removed. There was a lot of delays. 12 months was the minimum waiting time for ARs, administrative reviews, under the EU settlement scheme. All the clients have been complaining a lot of delays. Finally, this was just kind of a temporary transition provision that they had put in place since the Brexit happened, since the end of the transition period on 31st December 2020. And after that, they had 6 months to do the applications till 1st of July 2021. And subsequently, I think it was just to ease pressure of home office. They had given this administrative review right. Now home office has been observing that there are a lot of frivolous ARs being filed. Individuals who don't have any rights file applications, file ARs, just buy time, get a certificate of application, and they continue to work in the UK. This abuse has been happening, and home office is being aware of this now, and hence this seems to be one of the measures to stop that abuse, because then at least the time period that was wasted in the admin review, which was at least 12 months, some admin reviews are pending for 18 months and all and over and counting, as I hear from other lawyers as well. So the AR process has been completely taken out from the system for any EUSS application, which means pre-settled status, settled status. If you are outside the UK, if you are applying as for EUSS family permit, so say a husband or wife, the one of the partners has, so husband has EU settlement scheme, some status, either pre or settled status in the UK. Wife is applying to join. She would apply for a family permit from outside the UK, and then come to the UK and then apply under the scheme. So the administrative review has been taken out. So what was admin review? It's kind of a recheck by another caseworker. So if I am a caseworker who has made a decision, let's assume, and I have refused the application, so someone from the casework, someone else other than me from the caseworking team would check the whole application, the documents, and see if I have made the correct decision or not, or if I have made any mistake, I have ignored any document or something like that. So on some technicality. So that is how an administrative review works. It's not an appeal, it doesn't go to a third party. So finally they have cancelled this right completely for EUSS family permits, and also for S2 healthcare visitor visa, that's a special category. Then and the important part is it's a retrospective effect. So it's from this date forward. Any decision that is made on 5th of October, today is 2nd of October, so any decision till 4th of October, they will get, anyone whose applications are refused, they will get administrative review. But from 5th of October, once you get a refusal decision on your EU settlement scheme application, either family permit or pre-settled, settled status, whatever that is, you will not get the right to admin review it. The only option is right to appeal. You'll have to appeal to the first side tribunal, do whichever types of hearing you want, oral, paper, etc. There is still some delay in getting the hearing dates, but that is the only recourse you have. You go to the tribunal, put it in front of a judge. We do appeals. Yeah, we have several appeals filed. So if you are in this situation, you want to appeal, so there's only one opportunity you have, so that's appeal. Earlier there were two options. You would do the admin review. If that fails, then you would go for an appeal. So there were two options that the individual had if an application was refused. Now only one option would remain from 5th October 2023 onwards. Any decision that is made, not any application. So this is very, very important. Any decision that is emailed to the applicant from 5th of October 2023, then only appeal right will be given on that. So this is the biggest change that has happened in these recent changes, so that were published. Uh, Secondly, appendix service provider. So this is also a very special category. Only in that case they have maintained the AR. There are not much applications in this area that are being filed, so it's only for Switzerland. Then the another change was, this is also an important one, dependent parent or dependent child who has already proved their dependency. So any child who is over 18 years of age and they prove dependency on the parent, they have been granted, let's say, family permit. So this USS family permit or to come to the UK, or they have been granted pre-settled status under the USS, or either a dependent parent. Yeah, we've done several applications for children, for parent. Uh, yeah, we got something very similar where the parent is dependent either for essentials or any medical reasons, or they were a part of the same household, etc. Then in that case also, one, this is quite a welcome change that I would say, the evidence of dependency. So once you've shown that the parent is dependent on the first application, so under appendix EU, what that means is, if you shown at family permit, that's it, that's more than enough, that's also under appendix EU. Then you don't have to keep on showing that dependency at every stage. So let's say you got a family permit for your parent or for a child, showing the dependency, whatever financial transactions, transfers, or any medical reasons that you may have put, any other things that you prove that the person qualifies and they got the family permit. Then for the pre-settled status, you don't have to prove it again. The dependency requirement once proved, that's it. Under the same appendix, it need not be proved again. Also, it need not be proved for the settled status. Or so once it is proved under for any of the applications, you don't have to subsequently prove it for any further applications. So dependent parent or child has already been granted limited leave. So whatever leave, so if they have been given a limited leave, usually it means pre-settled status. So if that has been established, usually if you get a family permit, you are also given the pre-settled status. I've never seen any challenge on that. So if you given a pre-settled status, which is the 5-year visa or leave, whatever you call it, then you will not need to evidence the dependency after the 5 years when they apply for their settled status. So yeah, they need not be continuing to be dependent once they are in the UK. That's what it means. Seems to be they will not need to evidence dependency for any further applications under appendix EU, so they don't have to do evidence that. And the third one, it's also quite academic because the umbrella rights has been stopped now. Definition of required date has been clarified, has been slightly amended. That's not that relevant. The main ones are administrative review has been removed, so this is the biggest one. It's going to affect a lot of applicants, and so this is the worst change, and this is a better, I would say, a favorable change is for the dependent parent and dependent children. They would not be required to prove their dependency again and again. So these are the two main ones. I'll just mark them in red. Yeah, so these are the main ones I would put it. So yes, thank you very much.